the Judicial Council said, we can't stop landlords from filing complaints for eviction. When people have a beef with each other, whether it's a landlord against a tenant, a neighbor against another neighbor, you against the guy who rear-ended you, you can go to court and file a complaint telling the court what it is you want to sue this person for. And then that person files an answer telling the court their side of the story. And we call that a lawsuit. But one of the most important parts of that lawsuit is this summons. And Rule 1 prohibits the clerk from issuing the summons. The summons is the piece of paper that gives control over the tenant or the person being sued to the court. We call it jurisdiction. It just means power. The court has no power over you without a summons. It is the summons that gives the court power. So without a summons, the case just cannot move forward. So one policy change and some media attention basically stopped a 365,000 strong eviction tsunami that should have hit us in April and again in May. And then it picked up force in June. And we should have had 491,000 at least evictions in June. And there are some figures that go as high as 600,000. So it depends on, we don't have any we don't know exactly how many. They base it on the number of unemployment claims filed and other data like that. And so some estimates go as high as 600,000, but the most reliable is the Luskin estimate, which is currently at 491,000. But because of Rule 1, no summons can be issued. That way, the court has no power over the tenant. The case cannot move forward. There cannot be an eviction unless the tenant runs to court and files an answer. Now, there's a lot of talk about eviction moratoria. The eviction moratorium that the governor did, never did an eviction moratorium. He passed a rule that he called it a moratorium. It wasn't. It didn't do anything to stop evictions. The media called it a moratorium. It wasn't. It expired May 30th. Nothing changed. Nothing didn't help before. Doesn't help after. Losing it meant nothing. The governor, no moratorium. What the governor did is allow local government to pass laws. But none of the local governments have passed moratoria either. The closest thing to a moratorium is this Judicial Council Rule 1, which prohibits the issuance of a summons. Without the summons, there's no power over the tenant. The case cannot move forward. There can't be an eviction unless the tenant files an answer, in which case the court gets power over the tenant. And as a result, we were bracing for 365,000 evictions in April and May, 491 in June, and we got an average for those months of 350. And what's even more telling is that the pre-COVID average per month for 2019 was 3,381 eviction filings in LA County. So we lowered this number by 89% because of Rule 1, calm seas, no tsunami. Stop Tsunami 1. We call this Tsunami 1. And same tsunami, we just kept stopping it. Rule 1 disappears on September 1st, 2020. If you were on the last seminar that I did, I told you that Rule 1 would be in effect for 90 days after the governor lifts the state of emergency. But that the Judicial Council, which operates very independently, could take it away at any time. And they did, they voted. They tried to take it away in June, and we mounted a campaign and they changed their minds. And they tried to, and then on July 24th, they announced that it would end August 14th. We mounted a campaign, and the compromise was, or what we got out of them was September 1st. Their message is, it's not our job to legislate. And this is not really an administrative tiny little rule. This is something the governor should be doing. Governor, do something. This is something the legislature can do. Legislature, do something. They sent that message when they first passed it. They sent that in April. They sent that message on June 8th, 9th, and 10th. And they sent it again July 24th. And now they're serious. They are not going to extend Rule 1, but we can get the governor to replicate Rule 1, and we must do that. Because Rule 1 protects all tenancies, and it even protects foreclosed homeowners. It basically protects anyone that has possession of a property, no matter how they have it, from an eviction, because an eviction summons stops, and if you don't give one, it stops the process. And therefore, what we were expecting was 365,000 evictions filed, and then they would stop, right? But not that, it worked even better than that. Landlords, seeing how futile it is to file an eviction if you can't get a summons, just didn't file them. In a minute, I'm going to talk about how we're going to fight to replicate Rule 1, but I also right now want to tell you that in addition to Rule 1, there are other protections. So when we got the word that we're losing Rule 1, I got a ton of emails from people. But didn't the Board of Supervisors pass a rule that protects us till September 30th? Yeah, but that's another thing that is different from Rule 1. Rule 1 stops evictions. These protections from the County Board of Supervisors and from some city councils provide you a defense if an eviction is filed, but you have to go to court and fight. And that's problematic because there aren't enough resources to help 365, let alone 491,000 households. So the Healthy LA Coalition formed in LA County within days of the state of emergency being declared, with a mission of getting a moratorium, getting rent forgiveness, getting a freeze on rent increases, and getting protections for workers and homeless people. And that coalition for renters has managed to get the following: protections in the form of 3 to 12 months to pay rent. So depending on where you live, you either have 12 months to repay the rent. It gives us another 12 months to fight for stronger protections. The problem with even a 12-month repayment period is that too many of our families are what we called rent burdened. They pay way more than 30% of their income in rent. They're paying too much in rent. So when you tack on $300, $400, $500 a month to repay what they didn't pay during COVID, it just makes it cost prohibitive. There have been some rent subsidy programs, one at the county, Pasadena, LA, Santa Monica, West Hollywood, all of these local jurisdictions, but it's not nearly enough money. We would need $2.2 billion to start to touch the problem. And at most, if I calculate all the programs that have been instituted, it's something in the neighborhood of $300,000 that is available. So inadequate and very hard to get, and it's not really a solution to the problem. Sorry, I went ahead by accident. In some jurisdictions, there's only 3 months, and in others, 6 months. I'm going to explain right now who has 12, who has 3, who has 6. In all jurisdictions in LA County, if you did not pay your rent due to a COVID-19 related loss of income or increased expense, you are protected. So if you lost your job, had your hours cut, and it was because of COVID, you have a defense to the eviction and 3 to 12 months to pay back. And that technically there shouldn't be an eviction filing until this repayment period is over. If you had an increased expense. So for instance, I had a public housing tenant, mother with 4 teenage boys. So she's on CalWorks, so her income did not go down. But her rent is 30% of her income. So her rent, she should be able to pay her rent, except for her 4 boys normally have 2 meals a day at school, breakfast and lunch. And now they're home all day long. So they presumably also get some sort of snack at school. So they are literally eating her out of house and home because she can't afford to feed them. And so that made an impact on her ability to pay rent. That would be a COVID-related reason because of the increased expense. The other key element that we are fighting for in these laws is self-certification of loss of income. Many people work under the table. They are not going to have a letter saying you've lost employment. They're not going to have proof that they went to EDD to apply for unemployment, which is how you usually prove loss of income. And so in the county ordinance, you can just declare, I declare that I lost income, and how much. How many hours you worked, what was your salary before and after and now, and that's why you didn't pay your rent. So we're fighting for self-certification everywhere in LA County. And then these laws, these local laws passed by city councils and by the Board of Supervisors have different additional protections. So for instance, in both LA City and in LA County, if you are not protected by rent control, not protected by the Tenant Protection Act, which I will talk about, we talked about before, and I'll talk about again in a few minutes. So you could be evicted on a 30 or a 60-day notice without any reason, but not during COVID. But that only applies if you're protected by the county ordinance or by the City of LA ordinance. In some of the ordinances, we're keeping the utilities on. So you can have your utilities turned off for failure to pay. And so that's an additional protection, in others not. To know what law applies to you, you have to look at your own law, and before the session is over, I'll teach you how to do that. So countywide, there's different levels of protection depending on where you live. It's based on the city you live in, and I will explain that again a little bit more in a minute. Through policy advocacy and organizing, both through Tenants Together and Housing Now, which are 2 statewide coalitions, we are also now trying to convince the governor to replicate Rule 1. Replicate Rule 1. It's easier to say save Rule 1, but when we called the governor's office and said save Rule 1, they referred us back to the Judicial Council. And we've already decided the battle is not with the Judicial Council. They went above and beyond, protected people. I mean, it would have been fairer if they had kept their word and made it 90 days from the end of the state of emergency, even if we make that the current state of emergency, which is September 30th. So let me talk about that briefly. The governor declared a state of emergency in March that only went till the end of May. And then he extended it to the end of July. And now he's extended it to the end of September. And he will likely extend it again for another 2 months. Because frankly, what Mayor Garcetti did is a lot smarter. Garcetti just said there's a state of emergency and I'll let you know when it's over. So there's not this constant need to extend it. Every time there's a news report that the governor has extended the state of emergency, people think either, yay, we have a new protection. No, we have the same protection. He's just extended it. And mainly his state of emergency talks about local jurisdictions being able to pass laws is he himself has done very little. But more likely, when every time we get a news report saying that the governor has extended the state of emergency for a new date, people think, oh my God, it's over, when really it's an extension, okay? And it's likely to get extended again. As long as the numbers of infections and deaths are rising, we have a state of emergency, and it's likely to get extended again another 2 months. The LA County Board of Supervisors state of emergency is also until the end of September. And every local jurisdiction has done different things. Some have shorter dates, they extend them month to month. Some peg it to whatever the governor says. So that's what we call both the state of emergency and the local state of emergency. So what we want the governor to do is replicate Rule 1. When we called up and said, please save Rule 1, they told us, call the Judicial Council. And we don't think the Judicial Council is going to do any more. And we can't force them to. They're not elected. They're not vulnerable to public pressure the way that the governor is. So our fight now is with the governor. At the state legislature, we are working for AB 1436. That also provides 12 months to repay, but that then would provide that 12 months to everyone in the state, and we wouldn't have people with just 3 months. So that's one good reason for that law. But the better reason, the more protective reason, is that there is no evictions for COVID-19 related non-payment of rent. So if you don't pay at the end of the 12 months, then the landlord has to go to regular court, small claims court or regular court, get a judgment, and then try to collect that judgment, but they can't evict you, which addresses that public health concern about not having people lose their housing and having no place to shelter. You can't get a credit ding for COVID-19 related non-payment. Now, you can't stop an owner from filing an eviction court, but if they do, instead of you having to prove that you had a COVID-19 related reason for not paying, the owner has to prove that you did not. And if they file an eviction court, you get that self-certification. You can just declare it. You don't have to provide paperwork. Although if you have paperwork, you should provide it. And normally in evictions, we have 5 days to file an answer. If AB 1436 passes, we will have 30 days to file an answer. Another law that is being considered, which I frankly don't support, is SB 1410. This is the author. In this scenario, the government would buy the COVID-19 debt. The landlord will get a tax credit. The tenant has 10 years to repay. Nothing protects your credit, though. The eviction protections are very weak, and the landlord doesn't have to agree to do it, and it's very expensive. That's why we prefer 1436. If we had Rule 1 replicated and AB 1436, it would stop the 491,000 evictions. But the big question is, can we get this done? So the rest of this presentation will assume that Rule 1 has disappeared and that we are working exclusively with what we already have. What we already have, so there will be no Rule 1. What we already have is 3 to 12 months to repay and a defense to an eviction. This is the eviction process. Evictions start with a notice, 3-day notice to pay rent or quit, 3-day notice to get rid of that cat you're not supposed to have that violates your contract or quit, 3-day notice to quit because you're being such a bad neighbor that you're a nuisance, or a 30-day notice or a 60-day notice to quit because you don't have any rent control protections. They can be as long as 120-day notice, but most evictions start with a notice. If you don't do what the notice says within the number of days, the landlord files a complaint and is issued a summons. Right now and until September 2nd, no summons, so the case stops here. But after September 2nd, if you get a summons and you don't answer, you can lose automatically. We call it a default judgment, and the sheriff will come in 14 to 21 days. The sheriff was not locking people out. They stopped locking people out around March 4th. And last week, without notice, they started locking people out who lost their cases before April 6th, before Rule 1, and who were still in possession. And I tell you, it has been just heartbreaking, because we have a 24-hour emergency illegal eviction hotline, and that has been ringing. And in the last couple of weeks, 6 of those calls were from people being evicted by the sheriff with no notice. They got their notice. They got their notice to vacate in March or February even. But they were told that the sheriff wasn't doing lockouts, so they were sort of waiting for the crisis to end. And now suddenly they're on the street without any warning. And it's been really heartbreaking. It's very hard for tenants to find housing right now, because owners are afraid that you're going to move in and then stop paying rent. So owners are putting a lot of requisites, most of them illegal. And if you don't comply with them, they will not give you the unit. Okay, but what we're going to do right now, we're preparing answers and holding them. We are not filing them. But starting September 3rd, once you get your summons, we will file an answer. Then a whole bunch of stuff happens in here that I should probably put in. We propound discovery. They propound discovery. That's questions where both sides have to disclose to the other what all their evidence against each other is. Sometimes there's motions. There's all kinds of things that happen, but eventually a trial date is set. And then usually by the time a trial date is set, everybody knows how strong their position is legally, and we start settlement. And if we aren't able to settle, a trial happens and a judgment either in favor of the tenant happens and the tenant stays in possession, or against the tenant, in which case the sheriff comes, posts a 5-day notice to vacate, and then locks the tenant out. The time between judgment and lockout pre-COVID was 14 to 21 days. Okay, so less than 1% of tenants who go to court alone are successful. So you get these horrible scenes of displacement because people don't know how to present their evidence. People don't know how to properly fill out an answer. There's actually a 49% default rate, meaning not even knowing how to file that initial paper. And of the people that file a paper, 99% of those that go to a courtroom by themselves lose. This is what the notice to vacate looks like. Bright red. It gives you the date that the notice expires. So this lockout could have happened as early as the 26th of February 2018. So they don't come on this date. They don't come on the date that it says right here, but they can come as early as the day following. And after they come, they put one of these on the door. And if you open the door with after one of these is put on, you are committing a felony. Now, this is what we call the access to justice gap. I've already told you that less than 1% of tenants that go to court alone win, that there's a 48% default rate. So imagine how awful these figures then are, especially since losing an eviction means being thrust into an inhospitable housing market where you're going to pay a lot more in rent with an eviction on your record and a debt to the landlord that accrues interest of 10% a year or more. It is really horrible that in 2002, there were 73,000 filings, 1,300 people got help. That means that for every 100 people that walked into an office seeking help, 98 were turned away. Now, the Eviction Defense Network was founded in 2003, and our model increased representation over the course of the years. And by 2019, the system was representing a little over 5,000 tenants, households a year. And whenever we increase representation, this has held true in every jurisdiction that put more money and resources into eviction defense, filings go down. So in 2019, we had 40,572 filings, which is an amazing drop. And the gap became 88%. But look at what happens to our figures if 365,000 households are represented and we can only do 5,000. We lose all the gain that we've made in making services available. Now, there's another figure that we're working with, and that is that while 491,000 are at risk now, according to Luskin, we think that in a year, if we implement a program called Access LA, we'll cut those numbers down to 102,000. And I'm going to explain Access LA in a minute, which will allow us, which is greatly better. And so if we don't do anything, there's going to be a lot of displacement, and displacement leads to gentrification and to rent increases that are astronomical and to people being involuntarily displaced. But here's how we're going to stop all of that. There is a coalition called the Right to Counsel Coalition. We formed in March of 2018 to convince the city and the county to give us resources to represent tenants in eviction and to codify the right to a lawyer, meaning to put into the code that a tenant cannot be evicted without a lawyer, much like you can't imprison or put someone to death without a lawyer. We have the public defender system. The Right to Counsel Coalition is all 10 of the legal services providers that represent tenants and 12 of the organizations that organize tenants, like the Alliance of Californians for Community Empowerment and the Coalition for Economic Survival and SAGE as some examples. What that coalition is working towards is turning that 5,000 number to 30,000. And honestly, if we increase representation from 5,000 to 30,000, this 102,000 number will also plummet because landlords will need to come to the table and negotiate. Once an eviction is filed, the landlord cannot collect rent from the tenant. And if 365,000 or 102,000 evictions are filed and 30,000 tenants are represented, it'll take years to get the cases through court, which will incentivize settlements. The Right to Counsel Coalition launched phase 1 of a 3-phase program this past week. We have funding from the county to reach 1.5 million low-income households through media, social media, earned media, postcards, etc. The message we're sending out, and while this is not part of that outreach, I'm sending you the same message. Can't pay your rent? Don't panic. Don't worry. There is help. There are laws to protect you and services available. Even with the loss of Rule 1, you have protections. Don't self-evict. Don't move out voluntarily. Don't end up crowding with other family members. We are getting horrible stories of families doubling and tripling up, and then one person gets sick, and then a huge number of people then get sick because they are overcrowded, but also it just, the more people you have contact with, the greater the chance that you're going to contract COVID. So it's that message. Don't move, don't panic, stay sheltered in place. There's no reason for you to move out. We're also providing outreach and education, some door knocking, some phone calling, some texting to 100 high-risk households. And we're doing 120 virtual Know Your Rights webinars. I will post the 3 that Eden does in the chat. And providing limited scope legal representation to 8,000 of those households. So that's phase 1. And we don't know if by itself that stops Tsunami 2, but I will tell you that I'm spending a lot of energy focused on landlords with a message of don't evict people during the 12-month repayment period, because you don't want to meet a lawyer like me in court who will trounce you, make mincemeat out of you, because right now we have a 12-month repayment period in most of the counties. So wait the 12-month repayment period. What we're then hoping to do is launch something called Access LA. And this is where you have an opportunity to participate. There is no way that the existing legal services providers can help 491,000 households figure out what to do with their COVID-19 debt. But what we can do is train people, much like you're going through this training. We're developing a special 5-part training that will be given to representatives from social service agencies, medical providers, the education community, the LGBT community, neighborhood councils, immigrants' rights movement, the faith community, the labor rights movement and the workers' movement, youth justice groups, senior groups, the environmental justice movement, folks that fight for justice for the unhoused and the incarcerated, as well as the existing tenants' rights movement and private bar and legal services programs. So the idea is to have all these entities identify 5, 6, 7, 10 members, staff. So it's the reverend at the church, the priest and the rabbi. It's the receptionist at the medical health clinic. It's the college counselor or the other counselors that get this 5-part program. One on basic tenant rights, one on COVID tenant rights, one on how to negotiate a repayment agreement using a very specific 2-part form, one on the health impacts of housing instability, one on how to stop an illegal eviction, and one on how to identify a tenant leader. In addition, there's 3 weekly Zoom meetings in addition to the trainings that someone can go on. So the idea is Father Tom at my church and his staff go through the training, and all of their parishioners now have an advocate to help them negotiate their COVID-19 rent debt without losing their housing. So we go through the training and we give them the form, and they go forth and they make their pitch to the landlord, and the landlord says, oh no, we're not doing that, I don't agree. Well, they can come back to one of these 3 Zooms where we can problem solve and figure out how we can move that landlord into a settlement position. So that's Access LA. And we hope that folks here will join. The basic tenants' rights part of the presentation will include what we did in the first session with you. Anti-discrimination laws, anti-retaliation laws, what kind of notice has to be given before an eviction starts, what are your rights to go to court. It will also include information on the existing rent stabilization laws, what people call rent control laws. Rent control laws protect how much rent, how often the rent can go up, what percentage it can go up, and when. They also usually also have eviction protections. What are the reasons that a tenant can be evicted? Every law is different. Every law protects different units in the community. So for instance, in LA, to be protected, the building has to have been built before October of 1978. And single family homes are excluded. So you need to know the details of the law to know what the protections are. In LA County, the cities listed here and unincorporated county have rent stabilization laws, what people commonly refer to as rent control laws, but they are really rent stabilization laws. The difference between a rent control law and a rent stabilization law is that a rent control law has vacancy control, meaning the unit is protected. If the tenant moves out for whatever reason, voluntarily, because they were harassed, because they were evicted, the next tenant pays the same rent. It disincentivizes landlords from harassing tenants or from filing evictions. So vacancy control is a very good thing for tenant, but it was prohibited in California in 1996 by a state law called Costa-Hawkins. And so we have no real rent control laws, even though we've gotten lazy over the years and we call them rent control when they're not. We passed a statewide rent stabilization law called the Tenant Protection Act in 2019. It went into effect January 2020. So any tenant that's not protected by one of these laws is protected by the Tenant Protection Act if the building is at least 15 years old. Single-family homes are exempted unless owned by a corporation, and duplexes are exempted if the owner lives in one or of the units. But it's actually the broadest definition of protected units that we have, and almost, I mean, the huge percentage of tenants in California now have at least this protection. The problems with the Tenant Protection Act is that, right, it allows a rent increases of 5% plus the consumer price index. So that right now that's 6.25%, and that can be a lot. It caps the increases at 10%, which is also a lot. And there are some loopholes that are being used, including tenants are not protected till they've been there for a year. So we're now seeing landlords trying to kick out tenants at the year mark, creating a revolving door. So we need to close that loophole. Landlord can also evict a tenant and take the unit out of rent control by just doing $30,000 of renovations. And that in this market is almost nothing. But at least there is some protection. This is a map of the county. So this is the county right here inset into the state. And then this is the county of Los Angeles. The white areas are the unincorporated areas, areas that never became a city. The red, there are 88 cities within the county, 88 cities. The red is the city of Los Angeles, and the gray is all of the other cities. Of these 88 cities within the city of Los Angeles, approximately 40 passed their own laws, their own COVID protection laws. A lot of people call them moratoria. I actually get annoyed when people do that. They are not moratoria because a moratorium on evictions would prohibit evictions, right? And evictions can be filed, therefore there are no moratoria. There are defenses to those evictions in these laws. And the reason that's not good enough is that right now we're only set up to represent 5,000 out of the 491,000, and 99% of people who go to court alone lose. So we have a lot of work to do before we get to a place where we can say that people are safe from eviction. But to know what your local law says, you first need to know where you live. I had a guy in Pomona saying that the mayor of Los Angeles said he couldn't be evicted. Mayor of Los Angeles had nothing to do with Pomona. It's LA County, has 88 cities in it. The 88 cities are in gray, or 87 of them are in gray. City of LA is in red. And then there's the Board of Supervisors. And then there's unincorporated, which is governed by the Board of Supervisors. And this chart again, what we basically have is 3 to 12 months to repay, depending on where you live. COVID-19 is a defense to eviction and self-certification. I think at this point, I just want to talk briefly. We are working, this is the county eviction system. So there are 11 courts that hear evictions in LA County. And we are trying, that Right to Counsel Coalition is trying to set up eviction-free zones. So this, Pasadena West Covina is one, Norwalk Compton is one, Chatsworth Van Nuys is one, Lancaster is separate, Mosque is separate, Long Beach is separate, and we're not sure about Santa Monica and Inglewood. If there's enough money, we'll do them separately. If not, we'll merge them. And then what this means, it says that the entities, the agencies that are willing to provide services to reach 30,000 people in this 3-phase program that I talked about. The first phase is happening now, outreach and education. Don't move out, don't panic, stay, there's help on the way. The next one is that using the 12-month period to negotiate agreements using the help of already existing institutions like churches and social service agencies and senior centers, etc. And then when the 12-month repayment period, by then we're hoping to only have 102,000 evictions, families still at risk, put in full scope representation to 30,000 of those families, which will automatically make the number drop because landlords won't file if we're representing 30,000 because it'll take too long for them to get to trial. So that we hope that will stop evictions and level the playing field. And we will do that through organizing, policy advocacy, outreach and education with legal support, because we are, in every crisis, there are opportunities, and we are taking the opportunity to help people. And that, my friends, is how you stop an eviction tsunami. And we also have to remember that when we fight, we win. And at this point, I'm going to stop sharing my screen so I can take questions.
Thank you so much, Elena. That was such a great presentation, so much valuable information. We do have a couple questions in the chat box, and I do want to say thank you so much to Jorge for answering some of those questions that have come through. So for Elena, the first question that we have for you, Denise is asking, where can we refer a client who is in need of legal counsel for landlord retaliation?
Okay, so the place to refer anyone, and Jorge, can you help me do this? Because I don't know how to get back to you all. I'm connected. I don't want to waste time figuring out how to get out of my screen. So that you should send an email to askanattorney@edn.la. askanattorney@edn.la. I was hoping that by today I could give you the Right to Counsel Coalition's new website and hotline, but it's not ready. So if somebody does that, they will get plugged into every single entity that can possibly give them help is part of this network. So either we will help them for free, or we will refer them to someone who will help them for free. And if their income is above the eligibility guidelines, then we will refer them to an entity that charges based on ability to pay, that's also part of the coalition. Elena,
there was a...
So the best... Go ahead.
Sorry, there was another question that came in much earlier, and I think I know the answer, but I thought it'd be best for you to answer. And that was a question around, can a tenant file an answer without receiving a summons?
You can, but you must not. You can, but it's the equivalent of running to the court and saying, here I am, evict me quickly, I want to go now. Right? So why would you do that? You do not want to do that, okay? Do not file an answer. We need for folks to wait until they actually get the summons. But if you get a complaint, you should definitely send an email to askanattorney@edn.la, E for eviction, D for defense, N for network. What we will do is plug you into this website that is not running for the public yet because we're still getting the glitches out of it. But that website has an algorithm that will then refer you based on geography and your income to either a free or a sliding fee scale service, because it is so essential that people have representation and that they when they go to court. Okay. And so it used to be that as legal services providers, we would have people, we would have, so you would get a referral list. It would have all 10 agencies, and then you'd have to call them all. And then depending on the day of the week, somebody might help you or not help you. And then people would get discouraged, and then they would not do anything. And then we'd get them when they already had a sheriff's notice to vacate. No more of that. If you enter our system, no matter how you enter it, no matter which of the 10 legal services programs you enter through, or no matter which of the 12 organizing groups you enter to, you will be routed to the correct legal services program based on this geography that I showed here. And you will, so you notice it says what LSPs are working this court, what fee program, sliding fee program is working this court, and what CBOs are working this court. So you will be routed to one of them, and then they must help you until we've reached 30,000. After that, then there's two problems after the 30,000. One, no money, but also we need to recruit and train lawyers in order to go beyond the 30,000. We don't even have enough to do the 30,000. We just think we can recruit and train enough lawyers to do 30,000 cases if landlords wait through the repayment period. So after the repayment period, we will be able to train and recruit people. Whoa. Hi, Freddie. I'm not sure how you're on my FaceTime, but I'm making a presentation now. Can we talk later?
Yeah.
All right. Bye-bye. Sorry. I don't know how FaceTime works, but it always feels like a gross invasion of my privacy to suddenly have somebody in my living room when I didn't even touch the phone. So
a big surprise, definitely.
Yeah. So suddenly I see one of my adopted son's faces on my phone, like, what are you doing there?
You're like, oh, hi, good morning.
Yeah.
Okay, so it looks like Jorge answered a couple other questions. And to answer Sam's question, yes, we will be sending out follow-up materials after this presentation, and we will be making the recording available at labestbabies.com's website. So we'll send you the links for all of those. Are there any more questions, any last-minute questions for Elena before we jump onto our next webinar?
The other thing you will get is the links to two things. We have 3 webinars a week. We actually have the Right to Counsel Coalition now has something like, I don't know, 10 or 12 webinars a week. Eden has 3. So if you want to hear me again and connect with me and with my staff, you'll get those 3. Okay. You will also get, we do a training every Tuesday at 10 a.m. Every Tuesday at 10 a.m. You'll get the link to that. The webinars are for people who are having problems or people who just want to keep hearing the information over and over and over, because that's how you're going to absorb it. The Tuesdays are for activists or people who are doing counseling for others who want to learn the law more deeply. So it's the same stuff that I've talked about today, but we go into much more depth because it's 2 hours, the same material in 2 hours times 6 sessions. So you really, really learn the details of these rent control laws and what they say. I've given you just enough to spot an issue and to send people to the right place, okay? But if you really want to learn more, I recommend the Tuesdays at 10 a.m. And we will send you the link to that today so that you'll have it for tomorrow's session.
Yes, that would be great, Elena. Anything that you'd like me to share with the participants and the registrants, I'm happy to forward along. Okay, so if there aren't any more questions, we will give you back 4 minutes of your time. Thank you so much for joining us. And once again, thank you to Elena Popp and to Jorge Rivera for answering these questions and presenting all this valuable information. Thank you so much, everyone, and have a great day.
Do I stay on?
No, you need to log on to the next one. Sorry.
Okay. That's okay.
Thank you.
Bye-bye,
Thank you.
folks.